All rise. Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV16-0250, Osborne versus Arizona Medical Board. Counsel, we are recording today's proceedings, both audio and video, so when you step to the podium, if you would, please identify yourself and your client. Each side will have 20 minutes for argument, and appellant's counsel is responsible for watching the clock on the podium and reserving any time for rebuttal that you might desire. We have read the briefs, and we've conferenced the case prior to argument. So with those preliminaries, counsel, you may proceed.
May it please the court, Jim Sturinger. I'm a lawyer. I represent Dr. Osborne, who's seated behind me in the audience with his daughter. We're both from Tucson. What I'd like to do today is visit with the court regarding three specific issues in this case. The first issue is whether the board's decision to revoke Dr. Osborne's medical license unconstitutionally failed to apply this court's decision in Webb, which had required showing Dr. Osborne's treatment of patients SM and SJ created actual or potential harm unreasonable under the circumstances considering the standard of care. And the word unreasonable was a word this court emphasized in its Webb opinion. The second issue that we want to talk about today is whether the board's decision to revoke Dr. Osborne's medical license violated his rights to due process by denying evidence regarding SM's medical treatment and in the process leading to a knowingly false finding by both the administrative law judge and the medical board. The third issue we want to talk about, and in some ways maybe the more scintillating or the most scintillating of all of them, is whether the court below committed error by denying an evidentiary hearing where members of the board's investigative team could testify regarding whether they had communicated to any member of the board their knowledge that Dr. Osborne was under investigation by the DEA and the Department of Justice. Now, all three of these issues are de novo in nature, and obviously that dictates a certain standard of review issues. So now that we've talked about the three issues, let me start with Webb. And again, I want to reserve 5 minutes. I know I have to ask that, so I'm reserving 5.
We'll try to protect you, but...
Thank you.
No guarantees.
As of tomorrow, which is June 1st, Webb is 15 years old. It was decided in June of 2002. During that 15 years, it has withstood the test of time, meaning it hasn't been reversed by the Arizona Supreme Court. No member of any court of appeals has criticized it, and the legislature has chosen not to alter it or modify it one way or the other. The next thing that's important at the very outset is to talk about, well, what does 27Q say? It talks about any conduct or practice that is or might be harmful to the patient or a patient or a member of the public. That's it. Be wide open, and not surprisingly, in the Webb case, the lawyer representing the doctor, Dr. Webb, argued that, well, the statute is unconstitutional because it's vague and it's overly broad. And in the midst of making that argument, this court in Webb said, look, we have an obligation, a judicial obligation, to try to save the constitutionality of a statute by creating a construction that obviates arguments that it's vague or that it's overly broad. And this court's decision was basically, how we're going to do that is we're just going to decide that the legislature decided this regarding Section 27Q, that if a physician has a patient who has sustained actual or potential harm, it can only be a violation if that harm was unreasonable under the circumstances given the standard of care. And that's how this court 15 years ago salvaged or saved the constitutionality, so to speak, of the statute. Now, let's talk about how the Webb case played its way out factually in the administrative proceedings below. Not surprisingly, the proceedings began with a complaint. The state filed a complaint. They alleged a violation of 27Q, but they didn't talk about Webb, nor did they insert any of the Webb-related language. That's how this case began. In the course of a 5-day administrative hearing, the state called 2 doctors, Dr. Grove and Dr. Ruskin, and even though the doctors talked about actual harm and potential harm, the little template that they did their reports that way, but the state never asked either doctor any question, I mean not one question, as to whether any actual or potential harm sustained by either patient SM or SJ was unreasonable under the circumstances given the standard of care.
Well, don't they go specific? Doesn't Dr. Ruskin go specifically into the issue of the potential? You talk about potential harm, the potential of the dosages being prescribed killing these people. That was unreasonable. Didn't he specifically address that?
Dr. Ruskin did say at one point in time, well, it could kill people, okay. But he didn't specifically say it was unreasonable under the circumstances.
Sorry, he did not?
He did not.
But are you taking the position, did you take the position death was a reasonable circumstance for either patient?
I never took that position one way or the other because the state never argued the narrowing circumstance itself, so I never had to take that
I
position.
understand that, but you look at Webb and it talks about a physician coming to work with a head cold. Sure, that could be potential harm to patients. And so the narrowing limitation you talk about is absolutely what they said. But we've got a case here where both doctors testified at various times about the risk of overdose, either accidental or intentional, or death. And I don't think there's any contention that overdose or death would be reasonable under the circumstances.
Well, with all due respect, Judge, Dr. Grove testified that the opioid dosages prescribed by Dr. Osborne for both patients did not violate the standard of care, that there's no ceiling for opioid management, that is something all pain management doctors realize, that there is generally no maximum dosage when physicians are talking about pain management and opioids, and that the board has never established the maximum dose for opioids. That's the testimony of Dr. Grove.
But Dr. Ruskin specifically said there was a ceiling, and that ceiling was when the patient died, right? Because the potential for killing the patient through dosages was not a reasonable thing to do. And what Webb deals with is the issue of the thing when the prescription of the medication becomes more of a danger to them than what they're suffering as a result of the debilitation they have. That's not reasonable, is it?
Dr. Ruskin, in kind of an offhand response to a question really from the state, because the state asked the question, isn't it true that there isn't any ceiling for opioids? Okay. And his offhanded response was, well, yes, there is a ceiling if it kills somebody. Okay.
Well, you say offhand, but isn't that in fact true?
Well, an opioid, I guess, could kill somebody, but in this case, there's no testimony that it did, obviously, and there's no testimony that Dr. Osborne's prescription of opioids was anything contrary to the standard of care, because there's no ceiling.
Well, but that's circular reasoning. If he doesn't kill her, then there's no ceiling, so if he doesn't kill her, then it's a reasonable amount. But we've also got the issue of the potential for it to kill her, right? Isn't that the thing that...
We have that comment in an offhanded way from Dr. Ruskin. That is true.
Well, I think there's more. Dr. Ruskin testified that SM, and this is a quote, was put in a situation of extreme opioid dependence, and that death from opioid overdose, whether it be intentional or unintentional, that's clearly a risk here. So I don't think we have just an offhand comment. It seemed to me that we had more.
Well, Dr. Ruskin did say that. Specifically, I think he was talking about SJ, who in this case he never really testified about. That came out of his report. But Dr. Ruskin said a lot of things that just didn't come out to be true. For instance, he claimed that my client had no plan of treatment for patient SM, which was totally wrong. He finally conceded that.
You've changed the calculus here on us. You've changed the discussion. We're talking about the reasonableness or the unreasonableness of amounts of prescription drugs that can kill the patient, which would clearly be worse than them suffering the debilitation that they are there under. Now, I don't want to get into a philosophical discussion to you about right to die or anything like that, because that's not what we've got here. What we've got is a situation where the prescription of the drugs was in such dosages that the doctors said this puts them into a range where they do violate the ceiling, which is where the patient stands a chance of dying.
Well, let's get back to the court's opinion.
No, let's answer the question. That would not be a reasonable prescribing of meds, would it?
If a patient had died, that would not be reasonable.
So the test is the death of the patient.
Well, we're talking about the test from the Webb case?
I'm
or this
responding to
court's
your
personal
comment.
test?
You said if the patient had died, that would have been an overprescription.
I'm asking the court's question, yes.
So we can't assert or find that the doctor overprescribed unless the patient dies. Is that what you're saying?
That's correct. And if I could follow up on that a little bit, Judge, in the court's Webb case, okay, it talked about prescription medication, which it acknowledged can sometimes be too much. It also talked about oncologists who give patients chemotherapy and things of that nature. And the court acknowledged that in that kind of setting, the patient could die. Okay, so that's part of Webb. Okay.
But the court was saying in Webb, the court was saying that when you get into those cancer-related issues, where it's really nip and tuck as to what this person is suffering and what we're going to try and do to balance out that suffering with the relief they need, that there's the potential for having, there's almost that risk that becomes reasonable, right, based upon the alternative.
I think that's true.
But we didn't have that here. We didn't have a situation here where we should push the envelope right up to the point to where they may give in to prior addictions, or they may have other issues that, just simply taking the medication by mistake, whatever the thing is. We didn't have that here. We had some people who had issues, and we went from what seemed to be a reasonable amount of milligrams of certain opioids to twice that much, and then raising it again after that for no apparent reason. And that doesn't seem reasonable. When they're medically stationary, they're medically stable, to continue to increase those and have them addicted to the drugs that are purportedly helping them with what is a much lesser problem medically, I don't see the reasonableness of that.
Your Honor, Dr. Grove made a distinction between being dependent and being addicted. So there's a huge distinction between those two things. Secondly, there's no evidence in this case that my client ever exceeded an appropriate dose. In Dr. Grove's testimony, he acknowledged that, look, what I think is an appropriate dose versus what Dr. Osborne thinks is an appropriate dose may just be a disagreement among doctors, as opposed to something wrong, as opposed to something inappropriate.
And I think that's a valid point, but I'm looking at what Dr. Grove went on to say, and it was his opinion that, and this is a quote, the level of assessment in terms of the toxicology, referring to SJ, was substandard, and that the combination of SJ's medications could have caused respiratory depression or death. So I get what you're saying about it's not the dosage per se, it's the opinions of the medical consultants that the level of assessment and documentation was substandard, and their opinion was based on those factors it could have resulted in overdose, death, addiction. I totally agree with you. Dependence, tolerance are not the issues we're talking about.
He said that, that's true, but he didn't say it in the context of unreasonable under the circumstances.
But if you're agreeing death wasn't reasonable under the circumstances, I think we're quibbling over semantics. And Webb doesn't say that there have to be, I don't like the phrase magic words, but I'm going to use the phrase magic words. And this is a challenge as the statute as applied to your client. And as applied to your client, it seems the record would comport with Webb's limiting of the statute.
I disagree 100%, Judge. I think the statute requires that narrowing language. This court went to great lengths to talk about that.
So you're saying that Dr. Grove and Dr. Ruskin would have had to literally say, this is unreasonable under the circumstances.
Absolutely.
Okay.
That's what
They
this
use
court...
those exact terms.
Absolutely.
Okay.
And what's your support for that? Because Webb doesn't say that. And the legislature knows how to mandate findings of fact on specific issues when it wants them. Webb doesn't say that. The statute doesn't say that. So where do we draw that requirement?
Well, the requirement comes from the last page in Webb, where it says, surely this is what the legislature intended.
We know that,
And then-
that the
and then
board has to
specifically-
apply it in that limited fashion, but we don't have any authority that says the board or the witnesses must speak that magic phrase for it to comport with due
Well,
process.
The parting phrase in the Webb opinion is that on remand, the board may seek to apply the statute to the doctor.
It may
But
consider.
if so, it must do so as construed in this case.
Well, it says the board may consider, if it chooses to do so on remand, whether Webb's conduct was in violation of 25Q, so interpreted and defined, may
Right.
consider. But I think we're making a leap here that there have to be these magic words and magic phrases. And I agree with you, it would be helpful to everybody if the board would do that, and their counsel gave them good counsel in suggesting they do it. They went partway on the findings of fact, but not on the conclusions of law. But I'm not seeing where if the record supports that conclusion, that the absence of those words is fatal.
Well, I read Webb totally differently. That's all I can say, Judge. Because I'm at 4...
So when you get to the magic words, well, just for shorthand, you're saying not only does the board have to use those magic words, but the doctors have to use those
Absolutely,
magic words.
because the board's use of those words has to be based on some evidence.
But I mean, and that evidence has to have those words.
I believe so, yes.
Okay.
I'm at the 3.5-minute mark, so if I could reserve that.
Sure.
Appreciate it. Thank you.
Good morning, and may it please the Court. Michael Rain, appearing on behalf of the Arizona Medical Board. The Board did not apply subsection Q in an unconstitutionally vague manner in this case. In Webb, this Court said that any sensible construction of that statute would not prohibit doctors from prescribing medications that have potentially harmful side effects. And this Court used the example of chemotherapy and radiation, and as Judge Downey, you mentioned a head cold. Clearly, they said the legislature knows that these are reasonable harms or risks of harm that are just part and parcel of prescribing a course of medication. And likewise, opioids are dangerous and per se dangerous, but also create risks of other harms. And so that it fits right within that, of course, the legislature would not have intended to prohibit doctors from prescribing these approved medications simply because of those harms. Likewise, any sensible construction of this case would not find that the board applied Webb in such a manner. The board used expert testimony from Dr. Grove and Dr. Ruskin, the two outside medical consultants who are pain management specialists. They're board certified in pain management and in anesthesia. They regularly prescribe opioids. Logically, they didn't come in and say, just because you did that, you're below a standard of care.
Do they have to come in and say, because she didn't die, the prescription was reasonable?
No, absolutely not. And I think perhaps I'm somewhere in between the discussion that was just had with Mr. Sturringer and that point of death. Because in honesty to the court, I think both experts said, in a vacuum, there is no ceiling for opioids. There's no number. You're not going to get to 400 milligrams of this or that and say, you've crossed that threshold, per se, you behaved unreasonably. This case was all about the circumstances that these two patients came in with, and Dr. Osborne's briefs repeatedly point out how both experts said there is no literal ceiling. This would have been obviously a much simpler case if there was a magic ceiling, getting back to that word magic, but if there was this threshold, then what you'd probably have is just a few exhibits showing how much he prescribed, and that would be the end of it. I don't even know you'd need expert testimony. And so this isn't that case, and it's quite clearly not that case. It wouldn't look anything like it does today. And this case also wasn't necessarily all about the amount of opioids that were prescribed. Now, both experts testified, and the board's final order discusses that these were very high levels. We're talking 10 times what they were receiving from their prior treating physicians, or 7, 8 times what is considered a high dose. Plus, they were given in combination with other dangerous medications that have some kind of synergistic effects and even increase the danger. So I don't want to downplay the significance of the amounts, but, and I'll quote Dr. Grove, he said, this case was more so about the management of a patient who's on those medications, who has the noted red flags in their history. That's what was substandard. And so when you have these very high thresholds, maybe if you just looked at them in a vacuum, you'd say, I don't know. It could or could be above or below the standard of care. But if you are reaching that high level, if you are, as you said, Judge Jones, if you're pushing that envelope, you better be careful. And you want to consider every other option you have. You want to look at your non-narcotic treatments. You want to look at things like physical therapy, steroid epidural injections, weight loss, cessation of smoking. You wanted to try and take a more comprehensive approach. And what these experts found ultimately was that Dr. Osborne really just said, I'm a believer in the narcotics. I'm not a believer in those other treatment methods. And that's why I didn't do it. He doesn't really dispute that he didn't do these things. He just says, look, I observed him. I felt comfortable, and so I did it my own way. And ultimately, that's what this case was really about, that his way is dangerous, especially when his other philosophical approach is these high amounts of narcotics.
Let me ask you about the amended finding of fact that the board made to the ALJ's report at the Attorney General's request. First of all, the board adopted the finding of fact, not the conclusion of law. So part of my question is there any significance to that? But second, is the statement in amended new supplemental 95 that there was the potential for overdose and death, does that bring it into compliance with Webb?
I think under Webb, because there isn't this need to use the language, that it wasn't necessary to bring it under compliance with Webb. All the evidence that's in the record was in the evidence when this fact was admitted. I think it was a step in the right direction of addressing this issue that Dr. Osborne had been raising as to Webb. And so
I agree with you in part. However, I think the board would be very wise to make findings along the lines of 95 and perhaps even more, because our review is de novo when it's a question of law, and we need to understand whether the board had the correct standard in its own mind. And so I think the board went part way, but not all the way. What do we read into its refusal to adopt the proposed conclusions of law?
I honestly don't know what they were thinking there. I don't necessarily agree that the entire purpose of adding these conclusions of law was to address this narrowing construction argument that Dr. Osborne had raised. I think the state has always felt that that was not a proper reading of Webb, that you needed magic words.
Except, the prefatory remarks is to establish, this is from the motion that your office filed, to establish the unprofessional conduct under Q, in addition to articulating the standard of care. Case law requires the board to establish that the deviation resulted in harm or potential harm. Webb, so you agree that Webb requires harm. Your point is what?
Essentially that it wasn't to address the issue of whether the harm was reasonable. I think, I read the state's motion, I didn't make that motion, but I read it as focusing on, make sure we talk about the harm and potential harm. The standard of care is where the state has incorporated that reasonableness factor. And there was evidence in the record about the standard of care, and there was evidence in the record about harm. And I read that motion to essentially be saying, make sure we make that specific finding that there was harm or risk of harm. and not necessarily let's make sure we make a finding that it was unreasonable under the circumstances. But otherwise, Judge Downey, I'm not sure what else to make of it. They did adopt that finding. I think there was already some findings in the order about harm and potential harm.
Well, I read the transcript, and I wasn't at all clear that they understood what they were voting on the conclusions of law, quite honestly. But
yeah. But otherwise, to the extent we get beyond Webb on this case, it really does become a garden variety judicial review action, where you're going to look in the record and try and see if there's substantial evidence that supported these decisions. And as I've already said, this was somewhat of a philosophical issue. Dr. Osborne has a way of treating patients that the experts didn't agree with. The board didn't agree with it. It had already disciplined him in the past under Section Q. And so you need to look in the record and decide whether there's evidence. And of course, 5 days of hearing, 2 experts certified in this specialty testifying, countless exhibits. There's a lot of evidence in this record. And it kind of goes to a very quintessential board expertise matter. They're really drawing, they're obviously looking at the circumstances, but they're also drawing this line that says this is unsafe. And they're using their expertise to do that. And if they weren't bound by Webb to do something very specific, then you're really in that world of a standard judicial review action where I think you bump into that standard of review, and the board deserves deference in this question of its expertise.
But if the motion, if I understood you, if the motion that the state made was not to make sure that the board found that the risk, the harm or potential harm, was unreasonable, then how do we know the board made that conclusion? Or made that finding, if that wasn't the purpose?
The evidence demonstrates that, I think, quite clearly. As I indicated.
Well, the evidence might, but we're not, how do we know the board said, okay, we find that the evidence shows an unreasonable risk or harm, or unreasonable harm or unreasonable potential harm?
There's a couple ways, Judge. Number one is they incorporate that standard of care analysis. And I think that perhaps that's an inartful way to do it in light of that we're here having to talk about it.
No,
and
especially
of course,
if the state, if you're telling me the state didn't, that wasn't the purpose of the state's motion.
Well, at least that's not my reading of it, because it doesn't mention it, and it specifically focuses on the harm component. So it just didn't appear to me that while maybe paying a little homage to the issue being raised over and over again, I don't think that was the sole reason for it. But also, in addition to the fact that they incorporate the standard of care analysis, and if you have very high risks of harm, which are below a standard of care, I think per se, then they're unreasonable. But in addition, you have a lot of words that are very similar to what you get in Webb. Patient was rendered extremely opioid dependent for reasons that were completely unjustified. Words like that, as the state has pointed out in our brief, are equivalent. And I don't think if this court was inclined to say, surely the legislature knows the difference between a head cold and unreasonable conduct, surely the medical board does too. And so once you get, I think, past that, and you just realize, of course, the medical board wasn't punishing him just for prescribing medication with a side effect, then I think Webb is kind of irrelevant at that point. And you really do just need to look in the record and determine if it was reasonable.
Are unsafe and unreasonable synonymous?
No, I don't think so, because that's essentially what Webb's about, is medications.
Hence my question. Are unsafe and unreasonable synonymous?
No, because you can have things that are unsafe in one aspect, but intended to prevent a still greater harm. Chemotherapy is very unsafe. It hurts you.
But wouldn't that make it synonymous with unreasonable under Webb?
No, because under the circumstances of a patient receiving chemotherapy, it's a much better alternative than death by cancer. And so while it's unsafe, what Webb is really saying is, in a vacuum, it's okay that it's unsafe. Medications can be unsafe. You need to be careful and make sure that that risk is justified and that you properly manage that risk. And that's really what this case was all about, the management and the justification for what were very high risks.
Well, isn't perhaps an even easier answer to Judge Kessler's question, finding of fact 95, that says there was the potential for overdose and death? No one's arguing death was reasonable under the circumstances. Why isn't that the easiest answer?
Well, it's one of many things. I think there's also risk, by the way, to the public, which is another risk that's.
I'm just looking at what the board found.
Yeah.
I was just,
It's a simple, straightforward answer, is that you put him at risk of death. And perhaps with a lower dose of opioids, you wouldn't have such a great risk. And here also with combinations and red flags, that these patients had a lot of red flags in their histories, that risk was more pronounced. But I think if you want to just look at Webb theoretically, in a vacuum, you would say, if we only knew he prescribed these amounts of narcotics, yes, that could risk death, but in the appropriate circumstances, perhaps it might have been reasonable to, number one, prescribe it, and then hopefully under the second prong, you would appropriately manage it. And so they're very risky. No one disputes that, but I don't think Webb says that's where you stop your discussion. You really do have to look at the circumstances, and that's what this case was all about. Now, Dr. Osborne didn't get to his, Mr. Sturringer didn't get to his other issues. I don't really have much to add on the other issues that were raised in the brief, but I did want to make myself available to discuss those issues, including, the refusal to admit the evidence regarding the surgery post-hearing, and then there's the issue of refusing to allow additional discovery into possible hidden communications. I thought those were well briefed, and I would open it up for questions on that, but otherwise, I have nothing further to add. Okay, thank you.
rebuttal.
To this, I have 3 minutes and 35 seconds. The board's motion to modify, which was filed 2 weeks before the board hearing, or the state's motion to modify, followed on the heels from the administrative law judge's 21-page decision that makes no mention of the key case, the Webb case. Follows also on the heels of closing arguments that repeatedly talked about Webb. So when they filed their motion to modify, it's filed with the intention of complying with Webb. Yet, even so, they don't use the language, this court's language, unreasonable under the circumstances. Why the state didn't do that, I don't know. But I don't think the court can read into the board's finding that, well, somehow the board found that, because the state itself didn't even argue that in its motion to modify. Secondly, there's been some reference about magic words. And I don't want to get into the fact that most of those cases, or all those cases, are in the industrial commission setting, but let's just change the facts. Let's say it's a criminal case. Let's say we're talking about a jury instruction. Black letter law in Arizona for many years has been a case called State versus Portillo, which requires the trial court judge to specifically tell the jury what constitutes beyond a reasonable doubt. Let's say we have a criminal case, and the judge, for whatever his or her reason, doesn't give a Portillo instruction, doesn't use, theoretically, those magical words. What happens to that case on appeal? Not a betting man, but I'd be willing to bet that case gets reversed immediately for failure to use the words of Portillo that define reasonable doubt.
But isn't Portillo actually enshrined in the recommended jury instructions?
It is. Just like
Generally, a judge is going to say, I've got recommended jury instructions. The court told me, use this language. The court said, use this language. The jury instructions tell me to use this language. That's different than Webb simply saying it's got to be reasonable in the circumstances and not saying you have to use the word unreasonable.
well, the court and I interpret Webb differently. I think Webb salvaged that statute from constitutional claims of overbreadth and vagueness by virtue of adopting that narrowing construction. That saved the statute. Yes, I agree that most judges are going to give the jury a Portillo instruction, but I don't know the last time you practiced law in state courts, but some judges just don't do what they're supposed to do when it comes to jury instructions. And if they don't, and that case gets to the Court of Appeals, the failure to give a Portillo instruction is automatic reversible error. Finally, I've got 32 seconds. Let me talk about red flags. Counsel made a couple comments about all the red flags in this case. Red flags as to patient SM. There were two. One dealt with SM's adult son, who came to pay a visit. And during that visit, SM and her husband were out somewhere. And while the adult son was there, he found SM's drugs and took them. And when SM came back home, she couldn't find them, even though she had them in a lockbox in a closet. She had them secured, but she couldn't find them. Okay. Now, the state argued at the administrative hearing that, well, that's a red flag. Dr. Grove acknowledged, look, that was a first only occurrence, okay, and you can't always control what your adult son's going to do, and the best you can do is keep the drugs in a safe place and put them in a lockbox. That's what she did. That's not a red flag.
Your time's up, so if you want to wrap up real quickly.
Pool tournament, also not a red flag. SJ, her dog gets the drugs out of her purse, also not a red flag. There are no red flags in this case. Thank you, Your Honors.
Thank you. Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course, and at this time, the court stands adjourned.